case of the Cadillac that wasn't a Cadillac. I think this is a true story. So many years ago, a guy felt that he had arrived in life, and he went out and he bought himself a Cadillac, and he was feeling pretty good about it. And he drove it around for a while, and he bought it right from the dealership. He bought it straight from the dealership, brand new car. But it started to act up. There was something going on with the engine, so he brought it back to the dealership. And he said, I don't know what's wrong. Can you have a look at it? And they had a look, and he said, well, can you fix it? And they said, no. He said, why not? And they said, well, because this is a Cadillac dealership, and that's a Pontiac engine. And he was like, what? Why is there a Pontiac engine in my Cadillac? And they said, sir, we don't build them, we just sell them. So he got good and mad, and he got a lawyer. So what does he want to sue for? Well, there's a few things going on here. First, he wants to sue for rescission. And there's two kinds. There's mutual rescission and unilateral. Unilateral is where only one party wants to get out of the contract, and that's what we have here. It's where one party commits a substantial and material breach that defeats the object of the contract. And he's saying, yeah, that defeats the object of the contract. I bought a Cadillac. Hello, right? Okay, but there's something even more interesting going on here. And the issue is delegation. You see, Cadillac had to supply him with an engine. That's part of the car. But I guess there were too many Pontiac engines and not enough Cadillac engines. And so General Motors and the powers that be, they said, well, take the Pontiac engines, put them in the Cadillacs. And that's exactly what they did. So what he was trying to do was to refuse a delegation. And you can refuse a delegation, but you have to show that there's something material at issue, something important. The standard I like to use is judgment, taste, skills, and discretion. How is one thing different from the other? And this is where he got into trouble. Because in court they were saying, well, what's the difference? They're both made by General Motors. They both have 8 cylinders. They both have 360 horsepower. They both go 0 to 60 in X amount of seconds. What's the problem? He's just saying, because it's not a Cadillac. That's why. I paid for Cadillac, I want a Cadillac. That's not going to do it. If you're going to refuse a delegation, you have to say what the material difference is. And since he couldn't, he was stuck with the car. Yeah. Look under the hood. That's my tip for the day. And I always like to leave you with a little expression. So, a famous Roman philosopher named Cicero once upon a time said, I criticize by what I create. Well, that is the Sullivan Method, and this applies to law school and the bar exam. I think it's a far better thing in both instances to do a lot more application and a lot more testing. Testing is king. So check out our website, and let's work together sometime soon. For the Sullivan Method, I'm Dan Sullivan.